privileged to rise to speak on Bill C-203, introduced by the member for Drummond. Bill C-203 would amend the Supreme Court Act to require that judges appointed to the Supreme Court understand both English and French without the aid of an interpreter. Let me say at the outset, Mr. Speaker, that the Supreme Court as an institution already fully functions in both English and French. All services and communications of the court are provided in English and French. All those who appear before the court are free to use English or French in written or oral submissions. All judgments of the court are issued in English and French. All factums submitted to the court are translated, and during oral proceedings, judges and lawyers at the court have the benefit of simultaneous translation. So therefore, Mr. Speaker, it begs the question, if the court as an institution already is fully functional in both English and French, what benefit would Bill C-203 serve? Mr. Speaker, proponents of Bill C-203, it seems, make the argument, the crux of the argument being that judges who rely upon professional translators somehow will miss or may miss nuances in oral argument, which in turn will lead to the rendering of improper decisions. Mr. Speaker, the Supreme Court was established in 1875. For 142 years, the Supreme Court has heard and decided upon thousands of cases. And during the debate around this bill and similar, or frankly, I think identical bills that were introduced in previous parliaments, not one proponent of this bill can cite a single case that was decided wrongly definitively on the basis of translation errors. Not one case, Mr. Speaker. Moreover, in the event that a case was decided wrongly, there in fact is a remedy that is available. And that remedy, Mr. Speaker, would be a rehearing of the case. So, Mr. Speaker, it begs again the question that if there is no case that has definitively been decided wrongly on the basis of a translation error, and if there is already a remedy that is available in that very, very unlikely event, what purpose would Bill C-203 serve? Mr. Speaker, I submit that in the face of those facts, in the face of the evidence that what Bill C-203 is, however well-intentioned, it is a bill in search of a problem that doesn't exist. Now, what Bill C-203, however, would do, if it were passed, is it would create many, many problems. First, Mr. Speaker, it would significantly reduce the pool of qualified candidates for appointment to the Supreme Court. The fact is that outside of the provinces of Quebec and New Brunswick, very, very few Canadians are fluently bilingual. Indeed, Mr. Speaker, had Bill C-203 been the law, some of Canada's most distinguished jurists would never have been appointed to the Supreme Court, including Chief Justice McLaughlin, not to mention former Chief Justices Duff, Laskin, and Dixon. Justice Moldaver wouldn't be qualified to sit on the Supreme Court as he presently does. Justice Major from Alberta, who served on the court with distinction for 13 years, wouldn't have been qualified. And I could go on, Mr. Speaker. Sapinka, as the member for Durham correctly points out. Now, Mr. Speaker, while the purported objective of Bill C-203 is to ensure that nuances of oral argument are not lost in translation, I would submit, Mr. Speaker, that the likelihood of nuances being lost are much more likely to occur in the event that Bill C-203 were passed. Mr. Speaker, if translators at the Supreme Court, who are among the best translators in Canada, make mistakes, then what is the likelihood, Mr. Speaker, of a judge hearing a highly technical, highly complicated legal argument in his or her second language likely to also miss nuances of oral argument? Mr. Speaker, common sense dictates that it is a certainty, and I submit it as a certainty that will occur much more regularly if Bill C-203 is passed. And then, Mr. Speaker, there are serious practical issues. Would there be a test that would be administered to determine proficiency in English and French? Who would determine and who would be the arbiter of that test? What would happen to the current 9 members of the Supreme Court? Would they have to take a test? If they didn't pass a test, what would then happen, Mr. Speaker? So there are some, and that's just touching the surface of some of the practical issues that would be faced. So, Mr. Speaker, while Bill C-203 is a well-intentioned bill, it is a fundamentally flawed bill. Mr. Speaker, I fully agree that being able to understand English and French is a highly valuable skill for a Supreme Court justice to have. And, Mr. Speaker, I believe that it should be a consideration that goes into determining whether an applicant should be appointed. But, Mr. Speaker, linguistic characteristics must not trump experience, competence, and excellence in the law, not to mention the many other personal characteristics that are essential for a jurist to serve on the highest court in the land, the Supreme Court of Canada. Mr. Speaker, as I say, Bill C-203 is well-intentioned, but the problem with Bill C-203 is it searches for a problem that simply does not exist, to the detriment of appointing the most qualified candidates to the Supreme Court of Canada, and it is on that basis, Mr. Speaker, that I oppose Bill C-203.